Namaste students, welcome in online lectures, an initiative by Jayoti Vidyapith Women's University. I am Hans Kumar Sharma, Assistant Professor, Faculty of Law and Governance, Jayoti Vidyapith. Earlier, we have discussed about the culpable homicide and we have also discussed about the murder. Now, today we are going to discuss about the difference between both of them. The thin line is the intention behind the act. All murders are culpable homicide, but the vice versa is not true. Ever since the IPC was enacted, the distinction as to which case will fall under which category is a perennial question with which courts are often confronted on a plain reading on the relevant provisions of the code. It appears that the given cases can be conveniently classified into two categories. But when it comes to actual application, the courts are often confronted with this dilemma. This confusion often emerges when it is difficult to interpret from the evidence whether the intention was to cause merely bodily injury, which would not make out an offense of murder, or there was a clear intention to kill the victim, making out a clear case of an offense of murder. The most confusing aspect is intention as in both the provisions. The intention is a cause of death. Hence, you have to consider the degree of intention of offenders. If the person is killed in cold blood or with the planning, then it is murder, because the intention to kill is in a high degree and hot out of sudden rage of provocation. On the other hand, if the victim is killed without pre-planning in sudden fight or in sudden anger because of somebody's provocation or incitation, then such a death is called culpable homicide. Hence, whether the act done is culpable homicide or murder is a question of fact. The distinction between the two was aptly set forth by Sarkaria Justice in the state of AP versus R. Punnavya 1976 for SCC 382. In the scheme of the penal code, the culpable homicide is a genus and murder ex specie. All murder is culpable homicide, but not vice versa. Speaking generally, culpable homicide sans special characteristics of murder is culpable homicide not amounting to murder. For the purpose of fixing punishment proportionate to the gravity of this generic offense, the IPC practically recognizes three degrees of culpable homicide. The first is what may be called culpable homicide of first degree. This is the gravest form of culpable homicide, which is defined in section 300 as murder. The second may be termed as culpable homicide of the second degree. This is punishable under the first part of section 304. Then there is culpable homicide of the third degree. This is the lowest type of culpable homicide, and the punishment provided for it is also the lowest among the punishment provided for the three grades punishable under part 2nd of section 304. The term murder traces its origin from the Germanic word mord, which means secret killing. Murder means when one person is killed by another person. are a group of persons who have a predetermined intention to end the life of the foe. An offense will not amount to murder unless it includes an offense which falls under the definition of culpable homicide as per the definition of murder and the Writers' Code. All murders are culpable homicide, but all homicides are not murders. Section 299 and Section 300 of IPC deals with murder. What is murder as per Section 300 of IPC? Section 300 of IPC says, except in the case hereinafter expected, culpable homicide is murder if the act by which the death is caused is done with the intention of causing death. Or, secondly, if it is done with the intention of causing such bodily injury as the offender knows to be likely to cause the death of the person to whom the harm is caused. Or, thirdly, if it is done with the intention of causing bodily injury to any person and the bodily injury intended to be inflicted is sufficient in the ordinary course of nature to cause death. Or, fourthly, if the person committing the act knows that it is so immensely dangerous, it is so imminently dangerous that it must, in all probability, cause death, or such bodily injury as is likely to cause death, and commits such act without any excuse for incurring the risk of causing death or such injury as aforesaid. If we analyze the definition under Section 300 of the IPC, culpable homicide is considered as murder if the act is committed with an intention to cause death, the act is done with the intention of causing such bodily injury for which the offender has knowledge that it would result in death. The person has the knowledge that his act is dangerous and would cause death or bodily injury, but still commits the act. That would amount to murder. Now, what are the ingredients of murder? Causing death. There should be an intention of causing death. Next one is doing an act. Means there should be an intention to cause such a bodily injury that is likely to cause death. Or the act must be done with the knowledge that the act is likely to cause the death of another. We can understand this through illustration. Suppose A shoots B with an intention of killing him. As a result, B dies. Murder is committed by A. Another illustration we can read. Suppose D intentionally gives a shortcut to C. What I said? D intentionally gives a shortcut to C that is sufficient to cause death of anyone in the ordinary course of nature. As consequences, C dies. Here, D is guilty of murder, though he did not intend to cause C's death. The crime of manslaughter is termed as culpable homicide It is a term in the law of Scotland and England that covers a number of criminal homicides equivalent to manslaughter in legal criminal jurisdictions. Section 299 of the Indian Penal Code deals with culpable homicide, and it is stated, whoever causes death by doing an act with the intention of causing death, or with the knowledge that he is likely by such act to cause death, commits the offence of culpable homicide. The Penal Code has first defined culpable homicide. Simply stated, Section 299 IPC, termed as manslaughter under English law, which is genus and then murder, Section 300 IPC, which is a species of homicide. A person who causes bodily injury to another who is laboring under a disorder, disease or bodily infirmity, and thereby accelerates the death of that other shall be deemed to have caused his death. Where death is caused by bodily injury, the person who causes such bodily injury shall be deemed to have caused the death. Although by restoring the proper remedies and skillful treatment, the death might have been prevented. The causing of the death of a child in the mother's womb is not homicide, but it may amount to culpable homicide to cause the death of a living child if any part of that child has been brought forth, so the child may not have breathed or completely born. Homicide is the killing of a human being by a human being. It is either lawful or unlawful. Lawful homicide, it is also known as simple homicide, includes several cases falling under the general exceptions where death is caused in one of the following ways, like where death is caused by accident or misfortune and without any criminal intention or knowledge in the doing of a lawful act in a lawful manner by lawful means and with proper care and caution, according to Section 80 of IPC, where the death is caused justifiably, that is to say, by a person who is wrong or by mistake or fact, in good faith, believes himself wrong by law, says Section 76. By the judge when acting judicially in the exercise of an power which is or which in good faith he believes to be given to him by law, says Section 77. Further, Section 78, by a person acting in pursuance of the judgment or order of the court of justice, and by a person who is justified or who, by reason of a mistake or fact, good faith, believes himself to be justified by law, Section 79. By a person acting without criminal intention to cause harm and in good faith for the purpose of preventing or avoiding other harm to person or property, Section 81. Where death is caused in the exercise of the right of private defense of person or property, Section 100 and Section 103. Whether where death is caused by a child or a person of unsound mind or an intoxicated person, as will come under Section 82, 83, 84 and 85. Where death is caused unintentionally by an act done in good faith for benefit of the person killed, uh, when he or if a minor or lunatic, his guardian has expressly or impliedly consented to such an act, section 87 and 88, or where it is impossible for the person killed to signify his consent, or where he is incapable or giving consent and has no guardian from whom it is possible to obtain consent in time for the thing to be done with benefit, section 92. And now, unlawful homicide. Culpable homicide is the first kind of unlawful homicide. It is the causing of death by doing an act with the intention of causing death. An act with the intention of causing such bodily injury as is likely to cause death, or an act with the knowledge that it was likely to cause death. Without one or other of those elements, an act, through it may be in its nature criminal and may occasion death, will not amount to the offense of culpable homicide. Now, what are the essential elements of culpable homicide? Culpable homicide is the first kind of unlawful homicide as defined in section 299 of Indian Penal Code. It purports to define and explain as to when an act of causing death constitutes culpable homicide. The important elements are causing of death of a human being. Such death must have been caused by an act, like with an intention of causing death, or with the intention of causing such bodily injury as is likely to cause death, or with the knowledge that the door is likely by such an act to cause death. The fact that the death of a human being is caused is not enough unless one of the mental states maintained and ingredients is present. An act causing death cannot amount to culpable homicide. Thus, where a constable who had loaded but defective gun with him wanted to arrest an accused who was going on a bullock cart by climbing on the cart, and there was a scuffle between him and the accused, and in course of which the gun went off and killed the constable. It was held that the accused could not be held guilty of culpable homicide. Clause 1 to 4 of section 300 provide the essential ingredients wherein culpable homicide amounts to murder. Section 300, after laying down the cases in which culpable homicide becomes murder, states certain exceptional situations under which, if murder is committed, it is reduced to culpable homicide not amounting to murder, punishable under section 304 IPC and not under section 302 IPC. Exceptions are grave and sudden provocation, private defense, exercise of legal power without premeditation in sudden fight, and consent in case of passive euthanasia. Now, what are the punishment for murder and culpable homicide? Punishment for murder is defined under section 302 of IPC. It says, whoever commits murder shall be punishable with death or imprisonment for life, and shall also be liable to fine. And the punishment for culpable homicide is defined under section 304 of IPC. says culpable homicide is not murder if it falls under any one of the 5 exceptions given under section 300 for culpable homicide not amounting to murder. Section 304 of IPC describes the punishments as imprisonment for life or imprisonment for with a description of a term extending up to 10 years and or fine. Thanks for watching. Namaskar.